before you, Lord, to deliberate on a serious and most profound act. And we ask that you guide our wisdom and help us to deliberate in a way that is beneficial to your people. We ask all these things through your blessed Son's name, Jesus. Amen.
Any apologies to absent, Miss? From Mr. Matthew Sumuda. Anybody else? Senator Donald Scott, monthly. Okay. And thank you. All right, we're going to phase through this one. Before I do so, as chairman, I think we had what was essentially a side discussion on an issue yesterday, because it relates to a matter which we've been inviting the submitters to appear before the committee, but a small part of it was extracted and editorialized and published quite widely, and I want to reemphasize. In discussion with JRA, they made 5 recommendations and expressed a serious concern about, very serious concern about 2 of the 5, which relates to pistol and rifles. I made no comment on air guns or shotguns, which is a well-known popular sport, and in fact, from the day to day, no crime has been committed with a shotgun in Jamaica for a very long time. So I'll make it very clear, neither did my comment reflect what was in the law. It is an analytical comment. The Jamaica Rifle Association will be coming in to explain the submission, and the committee will have the opportunity to discuss the issues clearly and fully with the Jamaica Rifle Association. Lead again, we can begin.
Thank you, Chairman.
Section 2.
See, we are now receiving submissions from numerous entities, and I believe now being circulated submissions from the Jamaica Defence Force, the Jamaica Customs Agency, the Cornwall Bar Association, a group said to be the licensed firearm holders of Jamaica, Life Jam. Chairman, I would suggest that in the usual manner of creating a matrix in respect of the provisions with comments on clauses submitted on, that we would do so. It will be important for the submissions to be considered in detail, since the provisions of the new law will impact the persons quite profoundly. We concluded yesterday at clause 19, and this morning we will commence looking at part 3, starting at clause 20, dealing with the Firearm Licensing Authority. And just to indicate that there will be some amendments to the provisions in this part. All right, we'll ask the CPC to go through.
Good morning. 20, Establishment of Firearm Licensing Authority. 1, there shall be established for the purposes of this Act a body to be known as the Firearm Licensing Authority, which shall be a body corporate to which Section 28 of the Interpretation Act applies. 2, the provisions of the second schedule shall have effect as to the constitution of the authority and otherwise in relation thereto.
Madam CPC, may I just suggest we just skip over to the second schedule and just deal with that? as to how the authority is constituted. The authority already exists and it's just been re-provided for with
second schedule, which is on page 86, Constitution of the Authority. 1. Constitution of Authority. The authority shall be comprised of A, the Board of Directors, B, the Chief Executive Officer, and C, such staff as are appointed pursuant to this schedule. 2. Appointment of staff of authority. Subject to paragraph 4, the Chief Executive Officer shall appoint such persons to the staff of the authority as are necessary for the efficient operation of the authority. 3. Salary of the Chief Executive Officer. 1. Except with the prior written approval of the Minister with responsibility for the public service, given after consultation with the Minister, A. No salary in excess of the prescribed rate shall be assigned to the post of the Chief Executive Officer, and B. No appointment shall be made to the post of the Chief Executive Officer to which a salary in excess of the prescribed rate is assigned. 2. For the purposes of this paragraph, the prescribed rate is $8 million or such other rate as the Minister with responsibility for the public service, after consultation with the Minister, may prescribe by order published in the Gazette. 4. Salary of staff of the authority. 1. Except with the prior written approval of the Minister with responsibility for the public service, after consultation with the Minister, A. No salary in excess of the prescribed rate shall be assigned to any post, and B. No appointment shall be made to any post to which a salary in excess of the prescribed rate is assigned. 2. For the purposes of this paragraph, the prescribed rate is such rate as the Minister with responsibility for the public service, after consultation with the Minister, may prescribe by order published in the Gazette. 5. Benefits for staff of the authority. The authority may, with the approval of the Minister, A. Enter into arrangements respecting schemes, whether by way of insurance policies or otherwise, and B. Make regulations for medical benefits, pensions, gratuities, and other retiring benefits, or disability or death benefits relating to employees of the authority, and such arrangements or regulations may include provisions for the grant of benefits to dependents and the legal personal representative of such officers. 6. Seal and execution of documents. 1. The seal of the authority shall be A. Kept in the custody of the chairperson or the secretary of the board, and B. Authenticated by the signatures of 1. The chairperson or any other member of the board authorized to act in that behalf by the board, and 2. The secretary of the board. 2. All documents other than those required by law to be under seal made by and all decisions of the board may be signified under the hand of the chairperson, the secretary of the board, or any member of the board authorized to act in that behalf by the board. Continuing now back on page 21, clause 20, subsection 3. The authority shall be responsible for regulating, in accordance with this act, the licensing, importation, and exportation of firearms and ammunition into or from Jamaica, and without prejudice to the generality of the foregoing, the functions of the authority shall include A. Receiving, screening, and processing for consideration by the board applications for firearm authorizations. B. Receiving and investigating complaints regarding the breach of any term or condition of a firearm authorization. C. Conducting inspections and audits of 1. Licensed firearms and ammunition. 2. Firearm shooting ranges. 3. Firearm dealers. 4. Firearm trainers. 5. Gunsmiths. 6. Private security organizations. And 7. Any other person who holds a firearm authorization. D. ensuring compliance with the government of Jamaica's international obligations under treaties and conventions in respect of the firearms industry as provided for under this Act or any other relevant law. E, planning, implementing, and monitoring programs and providing information aimed at educating holders of firearm authorizations and the general public about firearms and ammunition, for example, in matters such as 1, the safe use and handling of firearms, 2, safety rules on firearm shooting ranges, 3, the importation of firearms, F, establishing procedures for the safekeeping, custody, and storage of firearms, ammunition, and accessories, G, establishing appropriate measures for effective stockpile management in respect of firearms and ammunition, H, establishing a register of approved firearm trainers, I, establishing programs designed to assess and develop the competence of firearm trainers, J, establishing and maintaining a register of approved brokers and their activities, K, causing, in accordance with this Act, the marking of firearms, L, conducting ballistic testing, capturing ballistic signatures in relation to privately owned firearms, and capturing related information with respect to firearms that are the subject of authorizations granted by the board. M, establishing procedures for the renewal of firearm authorizations. N, causing to be sent to the Institute for entry into the register, where appropriate, the returns received pursuant to Section 76(7) and the information required to be captured pursuant to Section 31(2). And O, performing any other functions in relation to firearms conferred on the authority by this Act or any other enactment.
Just, Ms. Grant, just wondering whether this subclause 3 should refer to the authorizations, because at 57, the license, the various form, just a matter of how it is worded. So it's responsible for licensing, but the Act uses authorizations, which captures the various license permits and certificates. But I note so the responsibility for regulating in accordance with the Act, licensing, importing, do we need to just reference or use? You can look back at it. We can just over at 57. So it's application for authorizations. But I'm just going to ask you to flag it. We're just going to flag it and look to see whether, well, perhaps we need to have to use the word there at some place, since it speaks to applications for authorization. Right.
At 3A?
The collectively, the license, permits, certificates are a form of authorization which is applied for and for which the authority has responsibility. It's just a use of the word.
No, I'm not understanding the point you're making. You're saying that this must be referenced here?
I'm asking the CPC to consider whether at 20 sub 3 we need to use the word authorization. Yes. Right. Yeah.
Instead of licensing.
Right.
Just for this thing, and in 20 sub 3, we should have more clearer reference to authorization. Sub 3 A and B speaks of authorization, and then C going to licensing.
Yes. Yes.
You'd like to see it? That wasn't quite clear on your request of the CPC.
So it's responsible for the grant of different forms of authorizations
Right.
in the regulation of the firearm, in the licensing process, the importation and exportation of firearm. But it may require a little more consideration, but just a note. All right, you can.
Board of Directors. 1, there shall be a Board of Directors of the authority. 2, the provisions of the 3rd schedule shall have effect as to the constitution of the board and otherwise in relation thereto.
Let's just skip over to the 3rd schedule. On page 87.
Third schedule, Board of Authority. 1, Constitution of the Board. 1, the board shall consist of the following persons appointed by the minister. A retired public officer who may be a person who has retired from the post of Director of Public Prosecutions. B, a retired judge of the Supreme Court or Court of Appeal. C, a retired officer of the Jamaica Constabulary Force, not below the rank of superintendent at the time of retirement. And D, 2 other persons appearing to the minister to be of high integrity and able to exercise sound judgment in the fulfillment of the responsibilities of a board member under this act. 2, the membership of the board shall not include any person who is involved in or otherwise associated with any relevant licensee as defined in section 76. 2, disqualification from membership of board. A person shall not be eligible to be a board member if the person, A, is not a citizen of Jamaica, B, is a public officer, or C, is the holder of a firearm authorization in relation to the conduct of their business. 3, appointment of chairperson. 1, the chairperson of the board shall be appointed by the minister from among the appointed members of the board. 2, in the case of the absence or inability of the chairperson to act at any meeting, the remaining members of the board shall elect one of their number to chair the meeting. 4, office of the chairperson or member, not a public office. The office of the chairperson or member of the board shall not be a public office for the purposes of Chapter 5 of the Constitution of Jamaica. 5, gazetting of appointments. The names of all members of the board as first constituted and every change in the membership thereof shall be published in the Gazette. 6, eligibility of members. 1, an individual is eligible to be appointed a member of the board if that individual, A, is a citizen of Jamaica and is 18 years of age or older, B, is not a member of either House of Parliament or other public official who holds an appointed or elected office of government, including local government, C, is not the holder of any office in a political party, D, has not at any time been diagnosed as having a mental disorder as defined in the Mental Health Act, and E, is a fit and proper person as described in subparagraph 2.
CPC, I'm sorry, you went further ahead, but I just need to stop because I'm so sorry. At paragraph 1, subparagraph 2, membership of the board shall not include any person who's involved in or otherwise associated with any relevant licensee as defined in section 76. Looking at section 76, is it defining a relevant licensee there? Because I'm seeing requirements of a relevant licensee, but I'm not seeing the definition of a relevant licensee.
It's defined at subsection 10.
Ah, okay. What a place to put it. Okay. So hold on. Okay. And so the membership of the board shall not include a person who is involved in or otherwise associated with any relevant licensee. What does involved in or otherwise associated mean? Involved in the business of that relevant licensee or associated, or what does associated mean? Related to them?
Friends of.
Yeah, what does that mean?
As it concerns associated with, the thinking behind it is whether or not the individual is a family member or generally associated by their friends or they're in business.
That's a rather broad interpretation for a country with only 3 million people. I mean, how do you bar someone on the board from being friends with somebody who is a licensee? How do you even know if they're friends with somebody who is a licensee?
Well, there's an obligation there will be an obligation on that member to disclose that relationship.
Okay, and so that relationship is disclosed on the basis of what? I mean, I know Nadine Wilkins over there, but am I going to bar myself from activity that she's related in? We're not that close, but I've known her for years. What's the quality of the relationship that constitutes an association? It is nebulous, and this is important because the constitution of this board is very important. And I understand the mischief you're trying to guard against, but I would wish to see specific language that would make you uncomfortable with appointing that type of a board member. So is it direct relationship in marriage, direct relationship parent-child, but it can't just be friends. I'm friends with a lot of people.
So what we could seek to do is to further qualify what exactly is meant by associated with.
Yeah, and that would create, I think, language in that might suggest that the nature of the relationship would create a conflict of interest, whether real or perceived is what I'm thinking you want to be getting at. Because that's the issue, isn't it? Yeah.
It is.
Thank you.
I share those concerns and observation of Member Golden, Chairman. Clear and very explicit. I understand the evil that you're trying to protect against, but as it is worded here, it's very loose and it can be problematic. Even in regards to related persons, what level, a second cousin, a third cousin, does that disqualify? Things of that nature. So that the general public can be aware very easily of who is disqualified.
Thank you, Member.
I'm going to suggest that we look at definitions in respect to connected party and how that is regulated, and then we come back to it, all right? And you can look under the Companies Act for some of the provisions there. But yes, as worded, it can cause unintended issues.
Mr. Chair?
Member Williams.
Yes, I just have a quick query here, or concern, in relation to Section 2 of the schedule, third schedule, Board of Authority, paragraph C. Oh, yeah, I was just looking at it, and I'm just seeking some clarification in relation to paragraph 2C, where it states that a person shall not be eligible to be a board member if the person is a holder of a firearm authorization in relation to the conduct of their business. So I'm just seeking some clarification on that aspect of conduct of their business. Specifically, is it that the person is ineligible if the person holds an authorization in relation to, a supermarket that the person operates? There's some clarification.
This could be clarified again in the here draft to say, but my understanding of this that you're relating to somebody like a gunsmith, firearm dealer, who needs authorization for those things.
Okay.
Directly involved in this. Mr. Bailey or Mr. Richards?
Yeah.
Sorry, you're essentially correct, Minister. I think our thinking was really geared towards those persons who would be beneficiaries of a firearm user's business license. So we wanted to eliminate those persons.
If it causes any ambiguity, you need to make sure it is clarified. It is clear.
Hold of which license?
Yes, it's somewhat a little
Ministers,
wide.
2C of the schedule. Go ahead, Minister.
Yes, I was just saying, yes, that clarification to me would be prudent, because it's somewhat a little wide or a little ambiguous here. So that, in my view, could be
Your earlier comment, Minister and Senator,
specified.
as it relates to Section 2 of association, the question of authorization, to what extent this need to be.
So it could remove any cloud of uncertainty in relation to, a proposed member.
331 in the schedule. Yeah. Chairman, the chairman of the authority is a very sensitive position when you read for example, the use of the seal and other. Really, is the authority of the chairman represents the authority of the authority, so to speak. And I believe the chairmanship should be very much above reproach, perceived or real. In 3.1, it just says appointed by the minister, but I'm not so comfortable with the provisions that can disqualify someone. For example, I would want to make sure that in the same way you're avoiding conflict of interest by board members and by extension the chairman from being associated with licensees in business as against a private user. Anyone who has been implicated, and I said implicated and relates to perception, in any activity in breach of the firearm, the FLA, that should, in my mind, be a disqualifying factor. In other words, Chairman, what I'm trying to allude to, if John Brown was involved in some gun activity, manufacturing of bullets, some things that was untoward, even though it has not been resolved in a conviction, I believe for the purposes of ensuring that it is above the activities of the FLA under this person's watch is above reproach. Such kind of antecedents should be disqualified because of the sensitive nature.
Six outlines in detail the eligibility to be a member of the board and says here the fit and proper. And in fact, in discussion, we want to be sure that it was even above the level of fit and proper financial institution, but certainly in line with that. That's what it is.
But even what constitutes fit and proper?
Eh?
What constitutes fit and proper?
Well, there are a number of things listed here, including not bankrupt, his employment record or other information does not give any reasonable cause for the belief that the individual engaged in any conduct involving dishonesty and impropriety that would interfere with the individual's ability to fulfill his functions. His shown probity and able to exercise competence, diligence, etc., which is not necessarily a conviction. Individual positive knowledge, skills, and experience required to function. The appointed individual not raise any issue of conflict of interest or undue influence.
And Mr. Chairman, I will tell you quite frankly.
You want some more?
Yes, and it is informed by some things that I have become aware of in the past that have come to my attention, particularly when I was shadowing your portfolio. I'm
going to send the past in, but...
No, you see the thing about it, Chairman, in all seriousness.
If you have any other parameter to add to this, we are welcome. No, yeah. I just want to make it clear.
I will look at it more in further detail, but those things were of concern to me, and I believe that we, now that we're going through this exercise, should make sure that sufficient safeguards against any... You see, I want an authority that nobody can question the integrity of the persons who serve, particularly in position of chairman and board members. Mm-hmm. That's really my concern. But I'll come back to it.
I think there's common understanding of that. Everybody in here wants that. It's just that...
to be as exhaustive as we can.
I think that 6 gave you enough room.
I'll look back on it and come back to it.
Look at it and go into exam. Just want to be aware of that, because that is a fundamental principle, because the FLA is the board that... It awards license at large, Nobody can award a license except the board.
Chairman?
Senator.
If I may, I do believe I understand where Member Jackson is going, and I agree with him that it's important for us to ensure that the members of the board are persons of integrity and of sound probity, etc., and some of that language is used here. But I have to caution against any attempt to put into law that we would make decisions restricting citizens of Jamaica from performing roles on the basis of basically rumors and suggestions as opposed to a conviction in a court of law. That is not a principle that I understand us to have operated by. Now, we may make decisions from an administrative point of view based on things we are aware of about persons, and those decisions may consider matters like that. But to put in law that someone may be, quote unquote, implicated without that implication having had the benefit of inquiry by a court of law or a due process mechanism would be highly inappropriate. And that's not something I certainly could support.
Thank you, Senator. I think the breadth of 6 covers most of what you are saying. We're a liberal democracy, and the elected officials have to make discretionary judgment within the framework of the law, and I think we'll do so with I think most of us at the ministerial level will expect them to have an understanding of sound probity and good judgment of the individuals they comment on. Yeah. So, but as I said, whatever is necessary to ensure that we have a board of a level of integrity required. And I think this section 6 has been added to since in the new law. I don't look at the old law. I think there'll be some addition.
Chair, to your point, 6D does give the minister appointing the discretion, because it is in the opinion of the minister that the person is of sound probity and able to exercise competence, diligence, and sound judgment. So there is that room to consider matters of the nature that Member Jackson is talking about, but not on the basis that, yes.
Just to go back to paragraph 2, If the intention of the schedule, person shall not be eligible to be a member, to be a board member, if the person at C is the holder of a firearms user's business license. All right, so we would specify that instead of in relation to the conduct of business. That's 70. That's provided for at clause 57(1)(j). If that is the form of license that it is targeting. Firearm user's business license.
57(1)(j).
So let's check if that is the license, the license that is targeted, and it will be specified, unless others may be involved.
I think it might have to be a bit broader than that, because there are other licenses related to businesses.
Right.
For example, if the person operates a shooting range or some, so it would have to include other licenses as well.
So let's just look back on it to see, so that it doesn't leave room for speculation as to what is intended.
There's a long list of things here and which would be impacted.
So the forms of authorizations in relation to the conduct of business is set out at 57. We will itemize them if need be, so that there is no room for dancing around.
Sure.
Chairman, I think I might indicate to you that in further perusal, 6.2c satisfies what my concerns are. I'm settled.
Also, just to say, reiterate what has been said, the issues that have arisen in respect of the constitution of the board of the authority have been taken into account. And so the schedule does two things. It disqualifies certain people, as set out at paragraph 2, and then it indicates eligibility, the eligibility criteria for appointment to the board, which would have to be properly considered by the minister in whom the power to appoint is vested.
Jackson, without prolonging discussion, bear in mind the way it is structured, if the authority has the sole responsibility of award license, if a minister makes a mistake, he'll have to take responsibility for it. There's no reserve right to anybody. It's the FLA board awards license and authorization almost at large. The review panel recommends, and you can always recommend to the board, but they do so. In this industry generally, the minister will have to take responsibility if they makes a mistake in terms of this issue.
Chairman, it is worth amplifying too that issues around politicization of the board has been addressed directly, and so members of either House of Parliament, whether you're appointed in the upper house and elected, including persons who are in local government, elected office, are not eligible for appointment to the board, nor is the holder of an office in a political party. And you know that we have moved in the direction of registration of political parties, and entire political activities are more formalized.
It would take care of one of your primary concerns, Member Jackson. That would take care of one of your primary concerns.
It was outside of that, but I'm satisfied that 6.2c provides for what I would want.
Okay. Paragraph 6 of the third schedule, subparagraph 2. An individual is a fit and proper person for the purposes of subparagraph 1e if A, the individual has not been convicted of an offense, one involving fraud, dishonesty, or moral turpitude, or 2, listed in the second schedule of the Proceeds of Crime Act, or an offense in another jurisdiction that is similar to any such offense. B, the individual is not a bankrupt within the meaning of Section 2 of the Insolvency Act. C, the individual's employment record or any other information does not give rise to reasonable cause for the belief that the individual engaged in any conduct involving dishonesty or impropriety that would interfere with the individual's ability to fulfill the functions of a member of the board. D, in the opinion of the minister, 1, the individual is of sound probity and able to exercise competence, diligence, and sound judgment in fulfilling the functions of a member of the board. 2, the individual possesses the knowledge, skills, and experience necessary for the intended functions to be carried out by the individual as a member of the board. And 3, the appointment of the individual will not raise any issue of conflict of interest or undue influence.
This is what you call the deep vetting. Deep vetting provisions.
7, remuneration of members. There shall be paid to the members of the board such remuneration as the minister with responsibility for the public service may determine. 8, disclosure. 1, a member of the board who is directly or indirectly interested in a contract made or proposed to be made or in any other matter being considered by the board, A, shall, as soon as possible after that fact comes to the attention of the member, disclose, either in person or by notice in writing, at a meeting of the board, the nature of the interest, and B, shall not be present during the deliberations or take part in the decision of the board in respect of the matter. 2, the disclosure of interest by a member pursuant to this paragraph shall be recorded in the minutes of the meeting at which the disclosure is made. 9,
Minister,
tenure.
Madam, before you leave this section, B is standard practice and considered best practice in relation to board members who might be involved in any kind of contractual or interest with a board on which they serve. But the comment made there of a member of the smallest of our society and relationship, given the nature of the Firearms Authority. I think this could be stronger. I must see minister colleagues. Essential man is going to have to take a contract from FLA and should resign because indicate before shouldn't he be allowed to attempt to get a contract once he's on the board?
Chairman, there are
I said I'm aware this is the
someone
best
wanted to
practice right
respond?
now, but the board is a particular peculiar station. Go ahead. Is the minister you're saying?
Chairman, I fully appreciate the argument that have been advanced elsewhere about everybody having a fair opportunity to benefit in commercial transaction. But I do believe that no member of the board, it's my personal feeling, no member of the board should have any material interest in the transaction of the entity. Material, I mean, commercial, monetary interest. I believe that the matter is so sensitive that the persons who are accepted to serve on the board must be serving solely on the basis of their expertise, their experience, etc., that they bring to the table. It can't be the case that you can only make a living if you are doing a business with this organization that you are serving in that sensitive position. And so they should be excluded, notwithstanding what prevails for other boards generally. But in this one, I believe that it should be an exemption. No board member should have any material benefit to accrue, directly or indirectly, from serving on the board.
My thinking, colleagues, and I shall be advised, I do overheard, in in the financial world, in the business sector, if you have a company and you sell it to another company, you are prohibited from, usually a part of the sale agreement, which sets a sensitive service, you are not allowed to enter that business for 2 or 3 years. Now, given the sensitivity of the FLA, I wonder if this particular clause should be amended, simply that the person should have no business connection, but in fact should not be allowed to in fact participate in the business activity with the FLA for at least 2 years after they have resigned. The life of the board is usually 3 years after they have resigned. Because it would still be easy for one to be a member of the board, seek a contract, influence its direction, while withdrawing from the meeting, right? And then come back in as well as resigning and getting the work he wants and go about the business. I say I'd be advising it, but I feel it's something should be looked at because the FLA, bear in mind, the FLA is quite a big business for those who are not here. FLA makes a significant profit and contributes to the consolidated fund on an annualized basis, anywhere from $3 to $7 billion, $200 to $700 million. You had a gap last year because of COVID, but that's the normal return. They fund themselves and have a surplus. And they do involve a number of activities and services required that they pay for and pay well. More members are allowed a stipend, which is better than other boards, but not part, need have to be improved. But given events alluded to from time to time, if this should not be, this clause should be restructured really. It's not so much an error here. I seek, go ahead, Senator.
Chair, I think I agree in principle with where you're going with that. My only caution to us in considering it would be that, to my understanding, we have a government-wide policy in terms of board members and the issue of conflict of interest and how that is dealt with. And I know that the Minister of Finance and the Public Service, in piloting the recent regulations on boards, there's a policy structure behind that. So I would suggest to the committee that may be something we want to raise with that particular ministry from a policy perspective, so that we support that uniform approach in terms of government. Yes, FLA is a particularly sensitive board, but we also have a number of other sensitive boards, and I'm aware that the provisions in relation to conflict of interest are quite similar to what we have written here that you disclose.
The PBMA Act is pretty strong.
Yeah.
And it should fit in, I agree. So but take a look. Ms. Wilkins, go ahead.
Thank you, Chair. I wanted to point out that, yes, this is pretty much boilerplate, but the principle is that you appreciate that an individual may be a director of an entity, and on one occasion that entity may be a bidder in an exercise or may be connected to a matter. So you allow this individual to acknowledge the fact that they have this connection with the entity, allow them to step out of the proceedings and take no part in the discussion. But you wouldn't say to them, you have to resign from the board for a reason like that. So the provision is there for that scenario. And in the context of Jamaica, it's a very, very possible scenario, because people are connected with companies, with individuals on a business level in all kinds of ways. So it's really there for that reason, Minister.
I understand the reason. I'm actually seeking, I said, dialogue, and suggestions have been made that we could be stronger on it, because although we are somehow cited, I did recognize at the very beginning, this is standard operating practice. Yes. And it's part of the PBMA Act.
It is
but if the nature of the body would allow us to look a bit further, and I'm not saying it's the decision that I'm asking us to interrogate it properly, because you do have, except the private sector operates in that kind of way, but with financial institutions, I'm aware that if you buy a company, a big part of the contract in purchasing is that you do not go in that business for at least a 2 or 3 year period, whatever they decide is the time, or if you're the managing director, cannot take a job in that field. Those are standard procedure as well in the good conduct of business, which is what the PBMA Act seeks to establish. You know, you take over practice, simple practice, you take over a law practice at 20 Duke Street, you just don't sell it for a fee to a number of partners, and you go up the road at 25 Duke Street and start another practice same time. You know, and so that's part of standard operating practice in transfer of services in the country. So I'd ask me to take a look at it because of the nature of the activity, and there is very high emotions and intent surrounding firearm license and business license and all that kind of stuff, which I think much more intense than standard company operations, as we have seen here. All right. So I'm not taking this here, but I think I'd love to look at it in that context.
I had my hands up for
Mr. Cousins, sorry.
What you're referring to, what you're referring to is similar to what them call a non-compete clause. Yeah, so basically,
thank you for the legal advice.
Yeah, I'm in full agreement with the recommendation, because the reality is that if somebody leaves an organization, that person would perhaps have an influence over the decisions of the organization. So what you're alluding to is the possibility of saying that this person should be excluded or precluded from engaging in any business with the organization or entity for a certain specified period of time, say 2 to 3 years. I support it fully, and I believe it's something that we should consider.
That's right to be considered. Minister.
Yes, Chairman, I was just reviewing the functions of the authority set out at 20 sub 3, and in respect of, so the direct interest, the challenge that you face is that other board members may give deference to a matter involving a member of the board, and you do not want any improper consideration to be given, but the issue has to be considered a little more holistically because of how the board is being constituted and what is required. So, I mean, we do have examples of impropriety. We do have examples of recorded conduct that has raised quite a bit of question. And these provisions would mean that persons really are going to be held to account, and we have to ensure that when you're vetted against the eligibility criteria and you're placed on the board, then we can minimize, if not totally eliminate, some of the problems that we have had in the past. The provision is geared at disclosing the interest and then recusing yourself. But bear in mind that we can look back on it. We can look back on it.
I raise it for discussion, Prime
Yes.
Minister. I think it needs to be a bit explored. I think all the comments looked at different angles of it, and it should be could be considered.
You know,
There has to be a disclosure of the full nature of the interest, and I think because that will give an indication when questions are raised in respect of how decisions are taken around it. So the disclosure of the interest pursuant to the paragraph is to be recorded. Member, the proposal was for a total disqualification of someone.
I actually looked at one in just for the FLA board, because the standard practice I said, and I reflected more on our PBMA Act, but given the nature of the board, that, and it's a small board, that you should not have any member on it seeking to gain any contractual relationship with the board, essentially, any material benefit. And it should not, the withdrawing is what is standard practice. I'm going further and say if they resign from the board to take the contract, they should still not be allowed to so do for a period of 2 years.
We do have rules in other areas of the
along those
law
lines.
where a discretion is given to you or a function is to be exercised by you and you're connected to it in any particular way. What is to happen? And generally is that you cannot make the decision So we can look at that related area. We'll flag it.
Chairman, oftentimes you have a board, and yes, I agree with the minister, in respect of the fact that an interest must be disclosed. But I think the mischief you're trying to cure is another scenario where there's a member of the board who resigns, leaves the board, but all of a sudden he has an interest in the industry, in the sector. And that interest comes about based on the fact that he has been exposed to the operations of the agency. So that doesn't treat with that, because that person's interest wasn't whilst he was a member of the board, He leaves the board and all of a sudden he ends up being a player in the industry. How we treat with that? So what you're proposing would cure that mischief. You understand?
Thank you, Member Cousin. I said, as my Minister of Justice is leading this discussion, we'll flag it and look at it more carefully, because I appreciate the discussion. It is a necessary view to look at, given the FLA board. You may continue, Minister. I think the comments have been thorough and supportive.
Tenure, leave of absence, resignations, etc.
1, subject to the provisions of this schedule, a member of the board shall hold office for such period not exceeding 3 years as may be specified in the instrument of appointment. 2, every member of the board shall be eligible for reappointment. 3, if any vacancy occurs in the membership of the board, the minister may appoint any person to act in place of that member. So, however, that such appointment shall be made in the same manner and from among the same category of persons as would be required in the case of an original appointment under paragraph 1.1, and subject to the provisions of this schedule, the newly appointed member of the board shall hold office for the remainder of the period for which the previous member was appointed.
Just a pause, Minister. You may want to consider whether you would want to restrict the reappointment perhaps for another term. So you may be eligible for reappointment for another period of up to 3 years, or you want to just leave it open so you have the same board forever and a day. Bear in mind that how the board is comprised of retired persons, and you really want to ensure.
What is this suggesting? That you appoint them to complete the term of the board, but you can reappoint the board,
No, 9.2 speaks to eligibility for reappointment.
Right.
Some provisions may say that you may be eligible for reappointment for another term not exceeding 3 years. It's just left open at this point. Right.
I hear what you're saying. It's a small board with a lot of rigidity. If we go the route that I just said, for example, we should just keep it in place, leave it open. Because there are a lot of retired people, and if you close 2 terms, given the narrow band of people appointing, then we run into the issue that was raised by one of our colleagues, that we're still a small society with a limited pool.
Well, persons retire at 65, it's going down a little at paragraph A. They retire at 70 at paragraph B, and they retire at 73. A decision doesn't have to be taken. I just raise it because there are other issues about the performance of the board and some of the comments that have come in, and issues around the timeliness with which matters are dealt with and just the energy of the board. Yes. Yes.
Bear in mind, it's a limited number. If you do, I'll say do 3 terms, not 2 terms, maximum. Being aware of what is happening, I said they are civil servants largely, except for the 2 appointed by the minister.
Proceed.
10, leave of absence. The minister may, on the application of any member, grant to the member of the board leave of absence for any period not exceeding 6 months, and may appoint some other person to act as member during the period of leave of absence so granted. 11, resignation. 1, any member of the board other than the chairperson may resign membership of the board by notice in writing thereof, addressed to the minister, and submitted to the chairperson, who shall transmit the notice to the minister. 2, the chairperson may resign membership of the board by notice in writing thereof addressed to the minister. 3, a resignation under this paragraph shall take effect as from the date of receipt by the minister of the notice thereof. 12, revocation of appointment. 1, the minister may at any time revoke the appointment of a member of the board if the member, A, is suffering from a mental disorder as defined in the Mental Health Act, or by reason of ill health is permanently unable to discharge the member's functions as a board member. B, becomes ineligible to be appointed a member of the board under paragraph 2 or 6. C, fails to discharge that member's functions as a board member in a competent manner. Or D, engages in any activity that can reasonably be considered prejudicial to the interests of the authority. 2, before taking any action under subparagraph 1, advising as to the revocation of the appointment of a member of the board, the minister shall notify that member in writing of the right to be heard on the matter of the proposed revocation within such time as may be specified in the notice, and shall give the member the opportunity to be heard accordingly. 13.
Chairman.
Minister, member.
If I may, Chairman.
I'm sorry.
With regards to the 6-month leave of absence, Chair, if I'm thinking if you can do without somebody for 6 months, why is it that, and we have appointed somebody in the place? You know,
Well, it says not exceeding 6 months. Eh? Eh?
Perhaps because you're comprising the boards of primarily retired persons and they may fall ill. I don't know. I mean,
yes, but
well, illness may attend on anyone at any stage in life. So let's not, I'm not saying it in a prejudicial way, but one doesn't know what circumstances.
On 12, I believe another E should be added. All of these board members are appointed. We set out the criteria that the minister appoints. I believe that any minister should have a clear discretion, even in the absence of any facts. If the minister feels that John Brown and the board has become a source of discomfort or any error, the minister, happens to be you now, but any minister should have the clear thing to say, I don't have confidence in this person, and revoke it. Because all the members of the board are being appointed based on the confidence that the minister has in each of those members. So I don't think the minister should be put in a position to, by virtue of the Mental Act. Suppose the man they don't get a certificate, but boy, all used to this man not behaving so right and all other reasons. The minister must have that latitude to revoke. After all the persons are serving at the pleasure or the discretion of the minister. The minister shouldn't be saddled by having to justify any of these.
It would be, and in legal language, and again, by the way, it can say if the minister loses confidence in the person, but I don't know how the A to D is quite comprehensive in terms of finding reasons to go. I don't know if, as I said, the elected representatives get out of some discretion, but they say if the minister loses confidence in the person, but we'll have to give reasons.
Minister, just to point out as well, that paragraph B in particular, it then refers you to paragraph 2 to 6, which would have had the fit and proper considerations. So if anything in the fit and proper considerations apply, then the minister
Which paragraph is that?
Paragraph B of 12, so 12.
Going back to
so
B as in boy,
B,
okay.
B as in boy, it then refers you to paragraph 2 to 6, which would contain the fit and proper
the original
considerations.
eligibility qualification. If it becomes known that the person fails to satisfy those qualifications, the minister can intervene because C.
And then we go even further at paragraph C to
Gives
talk
them-
about the function, whether or not the individual is unable or fails to discharge the functions as a board member in a competent manner.
Chair, can I want to make one comment in relation to Member Jackson's intervention, because as you rightly indicated, Chair, the paragraph 12 here does set out the reasons, and I caution Member Jackson on the approach that he's suggesting, because we then move back into a scenario where ministers can take decisions without reason, which is a scenario that I'm sure Member Jackson could, if that discretion is abused, find reason to say to this very parliament that it ought not happen. So where we have a system where the minister is giving a reason and the reasons are laid out clearly in the legislation, then that discretion has to be exercised in respect of those reasons. And then the minister has other discretion as well. But I just wanted to make another point too in relation to paragraph 12(1)(a). And I am echoing an issue that I know is very near and dear to the heart of my fellow Senator Longmore. We have this phrase in many of our laws. It's suffering from a mental disorder as defined in the Mental Health Act. And it's one I know that troubles my sister senator. And it also troubles me. The explanation we've had, because of course people can have mental disorders as defined in the Mental Health Act, but be functional and quite able to perform their tasks. If I suffer from depression, but I'm on medication and I am able to function normally, why should I be disqualified? If you're not disqualified by your diabetes, why should I be disqualified by my depression? And so I wonder, the explanation we've had, of course, is because that is how it is defined in the Mental Health Act, and the Mental Health Act, of course, is in need of major overhaul. But I wonder if it would offend even what we have in existing legislation if we were to include something that said is suffering from a mental disorder as defined in the Mental Health Act that prevents the person from performing the task that is required, something to that effect.
So the definition of mental disorder in the Mental Health Act actually presupposes that the condition must impair your ability to function. Because as defined in the Mental Health Act, it says, means a substantial disorder of thought, perception, orientation, or memory which grossly impairs a person's behavior, judgment, capacity to recognize reality, or ability to meet the demands of life.
Can you read the first three words of that?
A substantial disorder of thought.
So the person has a substantial disorder. And I'm saying you have people who are bipolar, who the disorder prevents them from operating normally, but they can take medication that allows them to function normally at a very high level. Right. So are they disqualified?
Member Golden, the concern is noted, but this really is speaking, it gives the minister a discretion in the revocation of a board member on a ground, and the matter would have to be considered and considered against performance, against issues raised. This is not going to be taken out, and I don't think, right, I don't think the concern that you're raising is grounded in the way this matter is provided for.
If I may add to you, Minister.
So your concern is a legitimate concern, but I don't think that this provision impacts that concern.
Senator, the issue of the Mental Health Act definitely reorganized, but if you read the whole thing in sentence, well, maybe because I'm medically inclined, it said, or by reason of ill health is permanently unable to discharge the member's functions aboard. I figure the separation of mental health activity, but is the question of ill health. So whether it's a diabetic paralysis damage or is a mental issue or is any other issue. Yeah, it's broad enough to
Thank you,
cover.
Chair.
Yeah,
Thank you.
I think that's how I'd see it. It should be interpreted. I think it would have been some grounds if interpreted that way.
Thank you, Chair. Thank you, Minister. as well.
I'm more concerned that having come to, and I've read this before, but doing it through in this way now, 12B, we speak upon a member of the board under paragraph, ineligible to be appointed, a member of the board under paragraph 2 or 6 becomes ineligible and raises the issue of somebody resigning and starting a business that relates to the board. When I say that, maybe we should in fact consider the comment I made earlier, that the person just resigns from the board, become ineligible because they know start a business as a result of their impact on the board. That's what 2 is suggesting. B.
But Chair, likely to the 2B, you could be serving on the board and then become a public officer.
That's one, but they start a business as a result of influence of the board, which is what we're alluding to. But
Your concern
is being concerned, so
your concern is they start a business by virtue of the time they have spent on the board and the inside knowledge.
The authorization, etc.
Understood.
We look back on that concern because it does raise a concern, similar to a kind of restraint of trade concern. So, Ms. Wilkinson, please consider the issue analogously in that concept.
I agree, but reasonableness has to be
Yes, of course, there is a degree. I'm just asking that you consider it
okay.
for discussion.
Discussion, okay.
13, proceedings of the board. 1, the board shall determine the frequency, time, and place of its meetings, but shall meet as often as necessary to carry out its functions. 2, subject to the provisions of this paragraph, the board may regulate its own proceedings. 3, the chairperson may call a special meeting of the board at any time and shall call such a meeting within 7 days after receiving a request for that purpose made by any 3 members of the board. 4, the chief executive officer shall attend the meetings of the board, but is not entitled to vote on any decision of the board. 5, the quorum for meetings of the board shall be 3 members.
I'm just pausing to emphasize this statement there because the chief executive shall attend the meeting of the board, is not entitled to vote on the decision of the board because chief executive has become the beating stick of the organization.
6, the decisions of the board shall be by a majority of its members present and voting.
Pause a bit. I just reflecting on that comment you made, Chairman. And shall attend. What happens if the board is considering a matter pertaining to the CEO and wish for him not to be there?
Ask him to recuse himself and make a decision on his employment or his employment.
Okay.
All done. I just emphasize because most things that go is very easy to any CEO, not just the president, the zeroing on the CEO because they have to do the investment.
Mr. Chairman, just back to 13.1. Why is it left so loose that the board shall determine the frequency of its meetings? Why isn't it an obligation for them to meet at least once per month and any other meetings that they may consider necessary in order to carry out the functions? And
if you want to put that in there, it's a once-a-week operation, at least. If they are going to put any parameter in there, the lowest you can put is once per week. But
I just said it because I did not appreciate that. But I think that there should be something there that stipulates.
There's a fair amount of the authority is the board, that does everything. They are the one allowed to. So it is now currently they meet about twice a week, So I'm saying if you're putting a restriction, they should say once at least not more than a fortnight. They have to meet fairly frequently to carry out the responsibility.
Fine, but I believe that it is that should be stated.
It's usually, except, of course, where the statute mandates, boards are normally given the power to self-regulate their proceedings and determine their frequency of meeting, having regard to the nature of the work. So the authority comprises the board and the CEO. And then the authority is responsible for a number of things set out at clause 20, sub 3. And then the responsibility of the board, separate and apart from the authority, picks up at 22. And then as we go through, you'll see the roles and functions of the others.
Six, the decisions of the board shall be by a majority of its members present and voting, and in any case where the voting is equal, the person presiding as chairperson shall have a casting vote. 7, minutes of each meeting of the board shall be kept in proper form and shall be confirmed by the chairperson as soon as is practicable at a subsequent meeting of the board. 8, the validity of a decision or proceeding of the board is not invalidated by any vacancy in the membership of the board or any defect in the appointment of a member of the board. 9, the board may invite the attendance of any individual at any meeting of the board for the purpose of assisting the board in its deliberations on any matter before it. 10, an individual who, upon invitation of the board, attends a board meeting, A, may take part in the discussions of the board, but shall not vote in any decision made during such meeting, and B, shall be advised by the presiding chairperson of the individual's duty of secrecy and confidentiality under this Act. 11, nothing in this paragraph precludes a meeting of the board being conducted by electronic means, and presence in relation to the participation of a board member shall be construed to include participation through electronic means in accordance with arrangements made by the board in the regulation of its proceedings pursuant to subparagraph 2. 14, protection of members. 1, no action, suit, prosecution, or other proceeding shall be brought or instituted personally against any member of the board in respect of any act done bona fide in pursuance or execution or intended execution of the board's functions under this Act or any other enactment. 2, where any member of the board is exempt from liability by reason only of the provisions of this paragraph, the authority shall be liable to the extent that it would be if that member were an employee or agent of the authority.
More legal explanation of this whole paragraph here. Sorry. It says the board member will not be, is indemnified. What exactly, give me a little bit, Minister, you can explain to me. I'm generally seeking clarification to see exactly what does this mean for the board member.
Paragraph are you speaking to?
Protection of board members. See, this actually prevents the members from being prosecuted individually. Is personally. Right.
It speaks to personal liability as opposed to the liability of the board or the institution. Right.
Okay.
Yes. And note the bona fides. So it has to do within the proper exercise of your authority. So it's just personal liability that you're shielded from. Yes. So, but there is vicarious liability so when it speaks to the authority being a body corporate to which Section 28 of the Interpretation Act applies, it means that it can sue and be sued in its own name. So instead of suing Horace Chang, board member, it would be the Firearm Licensing Authority as an authority. Yes.
Chairman, I crave your indulgence. I want to go back to 13.4. We discussed it a bit, but on further reflection, I have some imposing concerns. The Chief Executive Officer shall attend the meetings of the board, but is not entitled to vote on any decision of the board. Yes, you mentioned about the chief executive officer, recusing himself. But I'm thinking, Chairman, if the board wishes to consider a matter by itself as a constituted board and a constituted meeting, the word shall, and I stand to be guided or corrected, imposes. There's no discretion on the board for the presence. If the CEO say, I want to be in this meeting because the law says I shall be here, it doesn't provide the board with the opportunity to have a deliberation in the absence of the CEO. And I think that a board should be given that.
I hear loud and clear, Minister. And I'm going to ask the Minister to comment formally on it. Yes. But from a, again, non-legal point of view, I'm reminded of what they call the town meetings in the northeast of the United States, which copies an old practice of what they call essentially pure democracy. And in my touring, everybody in the towns come together and they discuss everybody's things. So the three police officers they employ, and they decide they're going to lay off one. The third one is there defending his place as well. They are involved, and in transparency that can happen. That if they want to lay off and he say, I want to hear what you have to say, fire me. I don't know if he has any influence on the board. It could be. I'm not opposed, nor am I supporting, but I think it's something that needs to be looked at, in interest of transparency. It can work. And so I actually went to that town meeting, and there was the teacher who figured that they need to stay on, a small town, and that was a priority. And they had 4 policemen, they figured one could go. And he's claiming that he just took student loan and went to college to do criminology, so he should be the last one to go, but he was the last one in. But they all sat in that meeting together and debated the issue. So it's not a unhealthy practice. It's just that something that society will do frequently. But I'd be open to advice on this one.
You see, Chairman, what is bothering me is that we repose a lot of responsibility on the board. We hold the board responsible for the administration and the executions of the organization, and the board sits above that executing body and to make deliberation and to take action. I believe that we will be saddling the board. We should give them the latitude to have a constituted meeting without any member of the in fact, the administrative body, which is headed by the CEO, is to provide the necessary information, data, and what have you that can inform the board's function to make a decision. That's its role. The ultimate decision making resides in the board. And I believe we are fettering the board a bit by saying that the CEO shall attend the board. So again, I think about it a bit, Chair, and the more I think about it, I think that the board should be given that latitude. I don't think we should fetter the board.
So, Chairman, may I suggest, I do agree that we will have to consider some qualifying words, because essentially is that the CEO shall attend when required by the board.
Oh, so I would fine.
Hold on. And when present is not entitled to vote on any decisions taken.
Something like
so
that.
let us just go through the part and look at the functions
your mind is
board.
going in the direction where mine is, Minister.
Perhaps those are the qualifying words.
Legal advice
but let's just
on a daily basis. Are you paying attention?
Well, that is certainly the intention. But you are correct that if it is cast like that without any qualification, then an errant CEO may demand that he be present on the authority of this provision when a matter which is to be conducted in his absence be done for the integrity of the authority and the functions of the board.
Those suggested words will cure the concern that I have.
Let's just go through the part and look at the functions that are being performed.
Sure.
that are specified, and then we will come back to it.
Good.
22, functions and powers of board. 1, subject to the provisions of this Act, the board shall be responsible for A, overseeing the general administration of the authority, B, in accordance with this Act, considering applications made under Section 57 for firearm authorizations and granting, renewing, suspending, revoking, and canceling such firearm authorizations as the case may require, and C, carrying out such other functions as are conferred on the board by this Act. 2, the board shall establish policies and procedures to govern the general operations of the authority, and in particular shall A, ensure that the operations of the authority are, where applicable, in conformity with 1, the Financial Administration and Audit Act and any financial instructions given under that Act. 2, the Public Bodies Management and Accountability Act. 3, any other law relevant to the management of public bodies. And 4, any directions given under Section 25. B, review, evaluate, approve, and monitor the implementation by the authority of the authority's 1, corporate policies, 2, operational, strategic, and other corporate plans, and 3, annual budget proposals and submissions, and C, review, evaluate, and approve the financial statements and major expenditure proposals of the authority.
Just pause here. So, Member Jackson, when you look at these functions, certainly in reviewing and evaluating and approving an annual budget, having regard to the function of the CEO, that is one of the meetings that one would expect the CEO to be present at and not be excused from.
Exclusion, you know, but the discretion to exclude.
3, the board may give directions.
I'm sorry. Minister, I understand Member Jackson's concern, but we have to be careful because the board of the FLA is a board that is not involved in the day-to-day management of the FLA. So I do not understand a board meeting necessarily requires the presence of the CEO to present the information and all that must be considered by the board. So the shall attend meetings, in my view, is sufficient and appropriate in the context of how that role between management and board has to be operated. If the board wishes to have a meeting where the CEO is not present, then in the power of regulating its own meetings, time and frequency, as is provided in the, I think that's the first, yes, the third schedule. Is it 13.1, right? The board can choose to meet. Now, whether or not that is considered an official meeting of the board if the CEO is present, I have a question about. But I don't see how, in other words, there should be no discretion for the CEO to not be at a meeting where, because the meeting is constituted on the basis that the CEO is bringing to the board the matters that the board needs to consider. How do we do that without the CEO?
I'm not suggesting that the discretion to attend the meeting should reside with the CEO. I'm saying that the board has the duty to require, and he has an obligation to be present if the board requires his or her presence. But my thing is as simple as that the board must be reserved the privilege to have a meeting among its members without the CEO. That's all. If at such time as and on such occasion that it deems it is necessary. Because there would be exceptional situation for which the board wants to meet without the CEO. But the shall in there removes that discretion from the board.
Yes, Madam Chair. I tend to see some merit in the concern of Member Jackson. Well, I have had the privilege of being a member of several boards hitherto my entrance into representational politics. And the practice, and based on my experience, yes, you do want the CEO to be present at board meetings because he has an obligation to report to the board on the operations and administrative functions in relation to the organization. And most times he's there because he or she is there because they have to report. And we rely heavily on the CEOs. However, I've had experiences where there are sensitive matters concerning the CEO, and of course, the CEO was asked to be excused and obliged. Now, I think what Member Jackson, I understand this shall, I interpret this shall to mean it is really, in my view, saying the CEO, you have an obligation to be at board meetings. However, the concern I think Member Jackson has, and I think I share the concern, is what if you're bitten by the shall? In the sense that you want to have a confidential meeting, a meeting that probably touches something sensitive in relation to the CEO, and you ask him to be excused, and he says, no, the regulations, the law says, I shall.
Bear in mind, I had actually asked us to just pause the discussion and let us complete this part, which is specifying. So we have the authority. We know how the authority is comprised of the board and and then we have the board itself, and that is set out. I understand the concern raised by Member Jackson to be saying that there may be an appropriate time when the board may wish to convene without having the CEO present. Perhaps the CEO may be the subject of the discussion or the manner in which the day-to-day running of the authority. And so the language should allow for that flexibility so that we do not have a CEO in an appropriate case saying, you cannot exclude me because the provision says that I shall be present at all meetings, although I'm not able to vote. So it's not difficult to resolve because neither do you want a board to exclude the CEO where the CEO is required to be present having regard to the functions being performed and the matters under discussion. So it's not a difficult fix if we're all agreed on what, right?
Guided.
But always we have to take care in what we provide to ensure that we do not have any unintended consequences. Yes.
3, the board may give directions to the chief executive officer with regard to the management of the authority. 4, in the performance of its functions, the board shall operate in a manner that maximizes the effective and efficient operation of the authority. 5, the board shall have the power to A, summon witnesses in respect of any matter related to its functions under this Act, B, call for and examine documents, and C, do such other things as the board considers necessary for the purpose of carrying out its functions under this Act. 6, the board may delegate to the chief executive officer any of the board's functions under this Act other than the function of granting, suspending, or revoking firearm authorizations. 23, Chief Executive Officer. 1, there shall be a Chief Executive Officer of the authority who shall A, be the head of the staff of the authority, B, advise the board on any matter relating to the authority, and C, in particular, shall carry out the functions listed in subsection 3. 2, subject to the provisions of the 3rd schedule, the Chief Executive Officer shall be appointed by the board with the prior written approval of the minister on such terms and conditions as the board thinks fit. 3, the Chief Executive Officer shall be responsible for the day-to-day management and operation of the authority, including A, planning, directing, supervising, and coordinating the activities of the authority, B, supervising and directing the work of the staff of the authority, C, developing and submitting to the board for approval the programs, performance targets, and service standards of the authority. D, implementing such of the programs, performance targets, and service standards referred to in paragraph C as are approved by the board. E, providing such administrative support as is required by the board. F, preparing, controlling, and managing the budget of the authority. And G, preparing in respect of the authority the annual report required under the Public Bodies Management and Accountability Act. 24, delegation of functions of Chief Executive Officer.
Maybe we would want to specify that that report is prepared on time, because we do have cases, it's a legacy issue in the Parliament where reports come in sometimes decades after, right? So it's not just...
But Minister, I'm not sure clearing my word, but I think under the Public Bodies Management Act, there's some stipulated time period for the reports
Annually, it's to be laid before the Parliament, and there is a time frame within which it is to be done.
That act.
But it's honored in breach instead of observance. You would only see what comes before the Parliament, and I believe, the time will have to come when we set aside parliamentary time to consider the reports that are submitted and not just take it for granted that they are read.
No, but I was saying,
Yes.
in respect of submitting those annual reports
Yes.
as are required, the Public Bodies Management and Accounting Act has a timeline specified in it. So it's a question of having them adhere to that legal obligation that is already in place. So it's really, really supervision to ensure
So this
obedience.
is a submission to, so let's just see, including preparing in respect of the authority. So what happens is that the CEO would prepare, have it signed off at the board level. The board would then submit it through the relevant minister. It goes to cabinet, and cabinet approves the tabling on it, of it. So you want the report, and particularly since we're kind of resetting the FLA, we don't want matters to be running in arrears. So let us just look to
Madam Chair, 22(2)A would cover it, because there's the responsibility on the board to ensure that the operations of the authority are in conformity with the requirements of the PBMA. So that would include
All
the
right, very well.
timelines specified.
But this should become part of the performance evaluation also for CEOs generally that are tasked with these responsibilities. All right?
I'm gathering, referring to the lady's reference to 22(2) is to saying that they should establish administratively procedures for adhering to the provisions of the Financial Administration and Audit Act. Anyway, I don't want to belabor, but I think that enough legal provisions are there. It's a question of not observing it more in the breach as is done.
What the CPC was pointing out is that at 22(2), there is a specific provision in respect of the functions of the board to ensure that the operations of the authority were applicable in conformity with the Financial Administration and Audit Act. So it's not just providing the report, but providing the report within the specified time frame. FAA, PBMA, and any other law, or...
Just a thought, Madam Chair. 23(2).
Member Jackson, may we just finish the next two clauses?
Okay.
And just make a note of it. And let's just finish the next three clauses. Yes.
24, delegation of functions of Chief Executive Officer. 1, the Chief Executive Officer may in writing delegate the exercise of any function conferred upon the Chief Executive Officer by or under this Act, other than the power of delegation, to such employees of the authority as the Chief Executive Officer thinks fit. 2, a delegation under subsection 1 shall not affect A, the exercise of the delegated function by the Chief Executive Officer, or B, the responsibility of the Chief Executive Officer in relation to acts of the delegate carried out in the lawful exercise of the delegated function. 3, any act done by or in relation to the delegate pursuant to the delegated function shall have the same effect as if done by or in relation to the Chief Executive Officer. 4, for the avoidance of doubt, a delegation under subsection 1 shall, in addition to conferring authority to exercise the delegated function, also subject the delegate to the same obligations as would apply under this Act to the Chief Executive Officer's exercise of such function, and accordingly, the delegate shall be liable for any wrongful act or omission of the delegate occurring in the exercise of that authority. 5, a delegation under subsection 1 of any function shall be revocable in writing by the Chief Executive Officer. 25, ministerial directions. The minister may, after consultation with the chairperson of the board, give to the board such directions of a general character as to the policy to be followed by the board and by the authority in the performance of their functions as appear to the minister to be necessary in the public interest, and the board shall give effect to such directions. 26, funds of authority.
Just note the concern, yes.
1, the funds of the authority shall consist of A, such fees as may be paid to it, B, such sums as may be provided annually by Parliament for the purposes of this Act, and C, such other sums as may in any manner become payable to or vesting the authority in respect of its functions. 2, the expenses of the authority, including the remuneration of members and staff thereof, shall be paid out of the funds and resources of the authority. 3, all funds of the authority not immediately required to be expended for the purpose of meeting any of the obligations or discharging any of the functions of the authority may be invested in such securities or other investments as may be approved by the minister responsible for finance.
What are referred to as the resources of the authority? I mean, this clause specifies the funds of the authority. That sells a building and pay the expenses? Just asking. All right, Member Jackson, while the technical team just note that for consideration. What was the issue?
For the delegation.
Yes.
You have the board, you have the CEO of the organization with various offices below the CEO. I would want to believe that there should be, if there isn't, an organization structure that identify the next in line to the CEO, so that whoever the person to be delegated the CEO's authority in his absence is known and is okayed by the board. Because what my concern is, a CEO just unilaterally choose anybody he wants or she wants, and the board, who is responsible for the organization, have no input in it. Whereas if you have an established line of command, you have the deputy. When the prime minister is not away, when the prime minister is away, we know who is the designated person in his absence unless otherwise.
Chairman, Member Jackson, there is a structure at the FLA, and perhaps the chairman, if the committee would benefit from a short presentation to inform what that structure looks like.
I'm not really interested in what the complete structure is at this point. Only as it relates to the delegation. of the CEO's authority in his or her absence.
So what you want to do is to fetter how the delegation takes place so it doesn't
don't-
move from top
I
to the
don't
very
like that
bottom.
word. No,
without
I don't
more?
like that word. The CEO, we all accept, is the critical role to the extent that that's going to be temporarily executed by somebody.
All right, take a read of it again. So this is the delegation of functions. The CEO is the head of the staff of the authority.
Yes.
At 23.1. And shall advise the board on any matter relating to the authority, and then carry out the functions that are listed. And in respect of the functions, in the exercise of those functions, the CEO may delegate. I'm not appreciating the concern that you're raising. All right, I would suggest that you think it through, because we're going to take the break now. We have to, the House will have to be prepared for Parliament. All right, so we are now up to part 4. Let me hand over to Chair.
Thank you very much. If we break apart, it's a good time to break, right? What page are we on? What page are we on? What page are we on? Minister, thank you very much. It's a good point to break because I said host coming at 2 o'clock. The members, we thank all the technical team members who are here. Thank you all for coming. I think we're going fairly well. My colleagues, thanks for your time. The next meeting is, next meeting is like Tuesday. No. Eh? Yeah, next Tuesday, March 15, same time, and Wednesday. We're taking all the sessions until we're going. Yeah, same thing. Yeah. Next Tuesday, we'll meet again.
Tuesday.
Yeah. At 10, we take this bill through, and we thank all the members. I think we're going pretty well given the nature of the bill.
Would it pose too much of a difficulty to members and supporting staff if we were to aim for a 9:30? On Tuesday, because of Parliament in the afternoon. All right, let's.
I find the start
or at the very least, aim for a prompt 10 start.
See? I think we should continue the physical for this thing because it's difficult to reason online with these, and a lot of the things are proving not contentious.
10 o'clock then.
Requires a level of interrogation. There's a bit of in position, everybody in place. Right? So we keep it physical.
And just to note that today actually is the deadline for the receipt of submissions on the bill. So
we have 8 submissions.
And we have to treat with that deadline almost strictly in order to get the work done.
The Bar Association asked for some leverage, and I think that's the only one we can take in after this. They did send a message asking to be allowed to submit a little bit late. All right, thank you, members. So adjourn until next Tuesday at 10 a.m. Thank you all again for your effort. All right, hold for me. I will leave the phone again. Call Donnie. All of these.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.